Out in the Pacific, the Federated States of Micronesia has built this legal system that's just fascinating. It's built on two really powerful and, yeah, sometimes conflicting ideas of what justice even is. We're talking ancient custom and modern law, all mixed together. So let's dive right in.
Okay, to really wrap your head around just how different this is, let's start with something that might sound, well, pretty shocking. What if the legal outcome for taking a life wasn't prison, but being adopted by the victim's family? Now, this isn't just some hypothetical question. It's a real thing in parts of Micronesia, and it tells you everything about their completely different way of thinking about the purpose of justice. So, right at the heart of the Federated States of Micronesia, you've got this intentional blend of two legal worlds. I mean, it's written into their constitution. On one hand, you have a formal system that looks pretty familiar to us, courts, laws, all that stuff. That's a legacy from its time as U.S. trust territory. But flowing right alongside it is this super deep-rooted system of customary law that's been the glue holding communities together for centuries. First, let's get into that traditional system. To really get it, you have to understand this one core value. The community's well-being is everything. A problem isn't just between two people. No, it's seen as a tear in the social fabric of the entire group, and that tear needs to be mended. Now, this slide really gets to the heart of it. It lays out the fundamental difference in purpose. Western law, for the most part, is laser-focused on the individual, right? It asks, whose rights were violated? Who's guilty? But Micronesian custom asks a totally different set of questions. How do we get the community back in balance? How do we heal this wound we all share? The focus just shifts completely from the person to the group. And the whole process reflects that goal. When there's a problem, it's not lawyers who rush in. It's the respected elders and chiefs. And their job isn't to judge a fight, but to guide everyone toward an agreement. The goal is restitution, making things right, which, you guessed it, leads back to that number one priority, getting harmony back for everybody.
And that brings us right back to where we started. This practice, it's a type of profound restitution, and it is a perfect example of the system at work. I mean, think about it. The victim's family gets compensated for their loss, sure, but it goes so much deeper. An act of violence gets totally transformed. Enemies become family. It creates this lasting bond of obligation and support. It's not about punishment, it's about rebuilding.
All right, so that's the path of harmony. But remember, there's another current flowing here, the formal constitutional system. This is the structure that came in as the nation became self-governing, and it was heavily influenced by the American legal model it grew out of. And when you first look at it, this all seems really familiar, right? You've got a constitution as the supreme law, a government with three branches, Supreme Court, state courts, the whole shebang. There's even a national criminal code that spells out crimes and punishments, just like you'd find in a lot of countries. But here's where it gets really interesting. Even inside this formal, structured system, they've built these explicit bridges back to tradition. This rule from Costa Rica State is a perfect example. It's written right into the court's rules that judges and lawyers have to consider settling things the traditional way. It's a formal acknowledgement that the old way is not just valid, but sometimes it's the better way. So, you have these two very different ideas of justice, and they're designed to coexist. But what happens when they actually crash into each other in a real-world case? Well, as you can probably guess, that's where you get some really fascinating friction. This saying, it just nails a key point of that friction: speed. In Western systems, we're all about efficiency, the right to a speedy trial. But this Micronesian expression, it captures a totally different worldview, one where hitting the brakes is actually essential to getting it right. So what might look like a backlog or an inefficient court to an outsider is often a very deliberate cultural choice. It's about letting the emotional heat cool down. The priority is to give people time to mend relationships, which is seen as way more important than just checking a box on a legal form quickly. It's not a bug, it's a feature of the system. And this tension really came to a head in a huge case, TAMD versus FSM. So someone had received a customary punishment, a retaliatory beating, and this practice ran smack into the Constitution, which, just like the US one, bans cruel and unusual punishment. The court had a massive question to answer: which system wins? The court's decision was incredibly smart. It didn't just say the custom was illegal, no. Instead, it formally wove it into the modern system. The court ruled that if someone has already faced a traditional punishment, the judge must consider that to lessen their official sentence. The court basically shared its power, creating a true hybrid system right there in the courtroom. And get this,
This mashup of two legal worlds isn't some accident that just happened over time. Nope, it was designed this way from the very start, written right into the nation's founding document.
This is what makes Micronesia's whole approach so cool and so different. In a lot of places, after a colonial period, the new state law just steamrolls the old traditional systems. But the FSM Constitution does the exact opposite. It actually protects and elevates custom, officially recognizing it as a real source of law.
And this one sentence, they call it the Judicial Guidance Clause, this is the bedrock for the whole thing. It's a direct command to every judge in the country. It says that your rulings in your formal courtroom have to line up not just with the Constitution, but also with Micronesian customs and traditions. This chart does a great job of summing up just how deep the differences go. In the customary way, the goal is harmony for everyone, and it's guided by a chief who is an authority figure, not some neutral observer. The outcome is about actions that restore balance. Now compare that to Western mediation. Goal is a private deal, you have a neutral third party, and you get a binding contract. They're just two fundamentally different worlds.
So why does all this matter? What's the big takeaway? Well, Micronesia's legal story is way more than just a cool local anecdote. It's a powerful, living example for the rest of the world. It's got huge lessons for any country trying to figure out how to make state law and indigenous law work together. It's a unique roadmap for building a national identity that actually honors the past while dealing with today's world. So, how does a nation balance its past and its future? Micronesia's answer seems to be that you don't have to choose. They're not opposites. Instead, they can be woven together to create a legal fabric that's stronger and more resilient than either one could ever be on its own. It's just a powerful reminder that justice can, and maybe should, have more than one voice.